True honor to be with you today as part of the Lyceum Initiative in these 6 talks celebrating the 250th anniversary of the Declaration of Independence. I hope that these talks and the Lyceum Initiative can help us in these troubled times to draw inspiration from those who signed their names to the Declaration of Independence and committed themselves to the task of forging a new nation out of a diversity of colonies in the midst of war, so that we can keep this great American experiment going strong into the future. I want to thank you, Dr. Gish, for your warm and generous introduction and for the invitation to speak to you today and to share thoughts about the nature of colonial governance as the historical and legal backdrop to the Declaration of Independence. Before we get started, though, I want to share a joke with you. I'm a big jokester, and my neighbors have prepped their kids to keep the jokes flowing. And last July 4th, the parents, and I know exactly how it came to be, sent a 6-year-old to tell me this joke. What did Luke Skywalker say on the 4th of July? May the 4th be with you. No? Okay. The little kid fell on the ground laughing, and we had to help her up and sweep the leaves off of her. So, Declaration of Independence for young and old alike. When Dr. Gish asked me to give this lecture and told me to focus on its first words, I acted the dutiful lawyer and historian and pulled out my dog-eared copy of the Declaration of Independence and Constitution. And for those of you who had me, yes, it's the same one that I was looking at in class with you. And I read anew Jefferson's sublime and eloquent statement that begins, "The unanimous declaration of the 13 United States of America." Oh, but wait, is that not the subject of this lecture? Just kidding. Okay, seriously. When in the course of human events. The Declaration begins in a moment, a suspenseful beginning, pregnant with meaning about a time during which decisions are made that alter the agreements that exist between peoples. And this significant moment is in one of the 2 realms in which man lives, history. History being the story of events that have causal connection and bearing on, here, not just American events, but human events, a grander stage. And in this singular moment, the American people will take control of their destiny and chart their own course in the magisterial story of mankind. Well, what of these human events that preceded the Declaration that impelled the signers to pen their signatures to it and choose independence? Scholars have educated us about the political, cultural, economic, intellectual, and ideological context of the Declaration and the American Revolution, weaving for us a rich historical tapestry that often focuses our attention on the rapid change, at times captured with words such as radicalism, transformation, and creation, of these colonial societies and of the colonists themselves, brought to the precipice of decision in the wake of wars and imperial machinations, who discover, latent in their culture, history, and politics, ideas that will impel them to choose independence rather than, as Thomas Hutchinson described it, submission. Though certainly not absent from our studies of the Declaration, but less frequently, have scholars taken up the study of the Declaration of Independence as a legal document. And I'm here today to say, let us not forget that the founders were framing arguments within a legal context that was profoundly shaped by their experience as practitioners of the law, governing in the colonies. They had experience as lawyers, as legislators creating and administering law, and as scholars who studied it. Work that takes law and institutional history seriously, rather than just as facets of political history, is most revealing when law is appreciated as an institution with a dynamic set of rules, institutional forms and processes, formal and informal, that creates order, expresses and constructs social norms, and resolves disputes. Law shapes human behavior through established processes that mediate, establish facts, settle conflicts, and it becomes embedded in society as a force unto its own that reflects values and principles, but also molds and gives voice to values and principles. As institutional history, the study of law becomes the study of how formal organizations, here governments, operate, and in the course of doing so, shape behavior, create and reinforce ideology, reflect societal norms, and influence long-term societal change. And as legal concepts are put into practice, law becomes factual and normative. Focusing on the law and institutional history helps us understand the principles of governance that include limiting principles, preferred pathways for resolution of disputes, and favored values expressed in the processes and outcomes of the law. Sovereignty, constitutionalism, and representation, among other concepts, were the subject matter of arguments that Jefferson and others framed in the dispute with the mother country as they sought to reconcile their pre-existing notions that found expression in the form and function of colonial governance with an imperial system, and with the mother country's ideas of how the empire was to be governed and the role of the colonial governments. This was not a philosophical debate from the colonial perspective, but a practical assault on colonial governments. So to understand their arguments, we must know their governments if we are to understand fully why the mother country's propositions were so offensive to the colonists. So what I have for you here today is a snapshot of how colonial governments functioned in the critical year of 1764-65. It relies heavily on the colony of Massachusetts, but is consistent and buttressed by evidence from Pennsylvania, Virginia, and North Carolina, the colonies I've studied, and in the all-important year here of 1764, the year before the passage of the Stamp Act and the emergence in full form of the crisis between the colonies and the mother countries. Were the arguments of the colonists about their governance posturing, searching, tentative, or were they confident pronouncements born of well-developed notions of governance? What was the nature of this governance that the colonists knew well? How far-reaching was it? How fully empowered were these colonial governments? These are some of the questions I've asked myself as I've looked at the evidence. So here for you, governance. The General Court of Massachusetts, composed of the Assembly, the Council, and the Governor, passed acts, laws. There were 35 of them in 1764. The public acts applied to all those in the colony, and thus they were impersonal and comprehensive. Many contained provisions for their expiration at some future date, which compelled the Assembly to revisit the issue, with the voice of the people being heard on the subject matter of the law because it was before the Assembly again. The General Court also passed resolves, orders, and votes. Resolves were legislative enactments that were the exercise of various powers, legislative, judicial, and executive, wielded by the Assembly. There were 287 of these resolves, orders, and votes in 1764, over 8 times the number of acts, and they were passed almost on a daily basis during the legislative session. Obviously, for many days, multiple of them were passed, and therefore gives us some window into functioning of the Assembly. Now, apologies to the scholar who emails me in a week, but as far as I know, virtually no one has taken, except me, has taken these resolves seriously and has integrated them with the laws to put together a full picture about how these governments actually operated. I'll show you a couple of them here in a minute. Resolves were requested almost always through petitions made by citizens. Petitions were not simply empty pleas or angry missives to the Assembly. They carried a formality about them because at the petitioner's request, if granted, was the first step in the creation of a resolve which carried the force of law. I continue to call them resolves because that's what they were called in the early 19th century. Today, for those of you involved in legislation, we would call this a resolution. Don't think of them in the way we often think of the right to petition the government today that is embedded and preserved in the First Amendment, that has devolved to angry emails and letters and then legal protection for lobbyists. The Assembly's response to a petition in the form of a resolve expressed legislative action of a temporary and immediate nature to a request born of specific circumstances and carried the force of law. They almost always have reporting requirements, empower individuals or committees to act, gather facts, and have requirements that the parties report back to the Assembly, and they invariably expire upon a date or upon performance of a certain act. By the way, they still exist. You can petition the Massachusetts Assembly using one today. I found them in the Massachusetts General Court Legislative Research and Drafting Manual of 2010. Resolves granted, authorized, directed, empowered, confirmed, released, apportioned, requested, incorporated, deducted, and accepted. A whole variety of particular actions in response to petitions. Their number and diversity show a close connection between people in the Assembly. The plethora of people acting as guardians, administrators, on committees of various sorts, and as delegates or diplomats reveal the extent of supervision and wide array of issues that the Assembly was overseeing. Here are a few examples for you. How do I, arrow key? Can you see these? Yeah. Nope, they're not up. Okay. There are examples of two of them for you. One on a petition of Benjamin Coffin, who was obviously reported to the legislature because the resolve here says that they were illegal purchasers of Indian land, and calls for the appointment of a committee that will review these purchases, assess the proper value of the land, and the rights of the parties in it. The one that's after it here is a resolve empowering a gentleman named Thomas Farrington, who was attempting to collect a debt of a party who owed him money and had sued for the collection of the debt, to file a process so that he can complete the collection of it after his lawyer was lied to about when the courts were to meet. So there's a whole variety of these, and each one tells its own little story of the people who are seeking justice through the legislature. And when we take these together, hundreds of them, they tell a much more full and composite picture about what the assemblies were actually doing. So by 1764-65, colonial governments wielded a quantum of power, an amount of power akin to Parliament, as they legislated over a wide array of matters, more commonly thought to be within the purview of a national government of unlimited powers rather than a colonial government within an imperial system. Assemblies passed acts and resolves that taxed to fund the colonial government. They regulated the money supply by providing bills of exchange. They borrowed funds and retired debt. They funded infrastructure, including the construction of bridges, roads, lighthouses, and powder houses. They conducted a census. They oversaw through appropriations and regulations a social safety net for the indigent, for disabled veterans, and the families of deceased soldiers. For the poor, the system also included a process by which the relatives of the indigent were assessed to see if they, in fact, should be caring, and if they were, the legislature assessed them a fee for doing it. The process also included the distribution of the relief through a bureaucracy, and we'll talk about that in a minute. The legislatures, dominated by the assemblies, and I'll tell you more about that in a minute, also managed an orderly expansion of colonial society. They regulated the creation of and relationship between districts, towns, plantations, and counties, all of which would enable subjects to enjoy the benefits of society and express their will over matters religious, political, and economic, and the legislature regulated how local meetings to resolve the most local of issues had to be conducted. The legislature also regulated public spaces. Think here commons, whether developed or wild, including docks, roads, fisheries, and oyster beds, and another one that was called swampy commons. They enacted laws that regulated the criminal justice system, and they empowered officials at the local level, including sheriffs and constables, to implement the law, and they funded jails. The Assembly also regulated foreign policy. These included the management through diplomacy and the appointment of officials in disputes with New Hampshire, Rhode Island, New York, and Connecticut, but also with foreign nations, including Canada, 11 Indian tribes, also providing support for French Acadians and diplomatic communications with France regarding a whole wide range of issues, including the return of captives, the treatment of French neutrals, and reimbursing money for the return of soldiers from the war. The resolves in the acts also indicate that during the 7 Years' War, the colonial government marshaled and equipped troops, billeted troops, defined desertion and the punishment for it, provided arms vessels, and managed the flow of equipment and soldiers through the war zone and to the front lines. In fact, this concept of fully empowered government actually found expression in an odd sort of way in the Declaration of Independence itself, through the absence of the grievance common about government today that was little more than philosophical banter in 1776, that being that governments had too much power, that government should be limited. We have a concept of limited government today that the colonists and their English cousins did not have. All they knew were fully empowered governments. That's why the list of grievances in the Declaration of Independence is all about the misuse, the abuse of powers, that power is being improperly used, not that there's too much of it. And in fact, the colonists, turned drafters of state constitutions, would utilize the same quantum of power in their new state governments. You can see this for yourself in those early state constitutions. There is no list of powers in them that limit the assemblies. And the rights are described as values, using the phraseology ought not rather than shall not. Why did they do this? Was it because they were unsure what the rights were? No, absolutely not. They did it because the governments were empowered to the same extent as the English government. They were fully empowered governments of inherent authority. The difference was that one would derive its power from the people, and that would be the radicalism of the American Revolution. Governments of inherent authority, empowered to with the same quantum of power as the English government, but now rooted in popular sovereignty. But that's a talk for later. The assemblies dominated colonial governments, including the executive and the judiciaries. The legislature chose what laws were continuing and which expired. They funded the governorship annually, which kept him on a tight leash, and they distinguished his appropriations from others, and they protected jealously their prerogatives against encroachment by the governor and the council. They managed the court system, they determined the pay of judges, and they determined the fees chargeable by those acting in the bureaucracies. Now, exactly when they got this powerful is a question worth asking, but I don't have an answer for you. The assemblies had, in virtually all cases for decades after their creation in the early 1600s, been ad hoc institutions formed within corporations or at the behest of the people beholden to nobles in proprietary colonies. And the assemblies acted tentatively for decades after their founding, in part because they didn't have official sanction from the monarchy. Their status and a pathway to empowerment changed in the wake of the Glorious Revolution of 1689. James II's reign provoked rebellion not only at home but also in the colonies, where James's appointed governor for New England was overthrown. William, when taking the throne, faced a problem as he sought to settle the empire down quickly and focus on European affairs. If he punished the colonists for essentially the same actions he had taken, he might well provoke more unrest, which he couldn't afford. On the other hand, if William openly sanctioned the colonial rebellion, then he would be acceding to attacks on the very monarchical power that he now wielded, which he couldn't do. So he found a compromise. He formally recognized the assemblies, elevated the governors, or so he thought, and created a formalized imperial system. The Glorious Revolution was not glorious for William, and it turned out in the long run not to be for the British imperial system, because the reforms ultimately failed if it was to keep the assemblies in check. Over time, the assemblies figured out how to use the powers they gained in the compromise, including control of budgeting, appropriations, and the civil lists, to exert control over the governors and the judiciary, while increasingly artfully marshaling popular dissent in opposition to the mother country's policies and its imported elite. And the assemblies were good at protecting their prerogatives. James Otis, a member of the assembly in the rights of the British colonies, had asserted in 1764 that there is no foundation for the distinction some make in England between an internal and an external tax on the colonies. Too often, Otis is treated as a unique figure whose arguments were unique for their time. They were not. A Massachusetts resolve in October 1765, passed by the Assembly, stated, quote, "All acts made by any power whatsoever, other than the General Assembly of this province, imposing taxes on the inhabitants, are infringement of our inherent and unalienable rights as men and British subjects, and render void the most valuable declarations of our charter." If there was some doubt about this, Governor Bernard wrote to the Lord of Trade in November of 1765 in response to queries about the nature of colonial assent that perplexed parliamentary observers. He commented that the Massachusetts Assembly was claiming, quote, "to have no superiors upon earth but the king and him alone in the person of the governor," which of course the Assembly had great control over, or according to the terms of the charter. The Assembly's empowerment was also evidenced by their power to adjudicate rights. The Assembly's balanced rights of debtors, creditors, widows, orphans, those dying intestate, absconding debtors, and the bankrupt against others claiming against them in the course of answering petitions with resolves. Some measure of this is balancing competing rights of individuals against each other, but some part of this is more powerful in the sense, more expansive in that what it's doing is regulating the boundary between individual responsibility and collective or communal responsibility. Now keep in mind that rights in colonial society were not wooden. Think like the First Amendment, which uses the word shall not. No. Rather, rights in colonial society were value statements. They're vitally important, but they could be compromised or qualified, even if not alienated by the assemblies, including with the use of bills of attainder. The nature of these rights, described in the English Bill of Rights with ought not language, were very important values rather than fixed barriers against governmental action. And this is consistent with governments that are fully empowered. The nature of the rights and the ability of the legislature to determine their enforceability contributed to the colonists' sense of empowerment. The assemblies mediated and defined rights in the course of operating within a system with an unwritten constitution and the common law, but also in which rights had been codified as early as 1641 in the body of liberties, which were enhanced with the English Bill of Rights from the Glorious Revolution, and also found expression in the 1692 Charter in Massachusetts. Rights codified and unwritten, expanded and enhanced, enforced and preserved, created a legal culture rich with the perception of rights that, while not expressed in a manner to protect individuals from Parliament, did protect individuals from government. And here's what's most relevant here, and it's an irony. This contributed to the perception of the colonists that their governments were fully empowered. I say ironically because it's odd to think of people coming to see their governments as more empowered in a framework with lots of rights. But if your government has the power to mediate the rights and qualify them, then it wields real power. These rights would continue to be expressed as values, importantly, but ones that could be qualified by the assemblies, even in the new state constitutions drafted in the wake of the Declaration. So again, more consistency here. Fusion of powers. The assemblies handled matters judicial, executive, and legislative, like another government of inherent authority whose practices they had studied. The English one, Parliament did it. And I'll give you a category as an example here. And in the 1764 session of the 287 resolves, 48 of them are probate matters. And 48 of these, during this session, reveal the Assembly acting in a judicial capacity to resolve probate matters by facilitating the payment of funds to satisfy debts incurred by the deceased, the care of minors, the protection of minors' assets, and the preservation of dower estates. 28 clearly involved the disposition of assets from those who died with wills. 11 involved those who died without wills. And they showed the Assembly making its best effort to resolve complicated estates in ways to ensure the payment of just debts and to find ways to maximize the resources of the estate for heirs. All of these cases that I have enough information to evaluate, and it's most of the 48 here, involve the application of a set of rules and principles that pay the debts, preserve real estate, and wherever possible, facilitate the sale and distribution of funds from the sale of real estate to heirs. In 19 of the 48, guardians have been appointed. Why? Because the guardians are looking after minors who've inherited. The guardians were paid and they were supervised, and a lot of these are petitioning on behalf of minors to ensure that the sale of real estate is in fact in the best interest of the minor. Next, the bureaucracy. The bureaucracy of the colonial governments was not some impersonal set of institutions that might prove frustrating in the way that we think of bureaucracy today. The bureaucracy then was local, it was personal. It was actually the representatives and the selectmen of towns themselves, in most cases, who were assigned the task to, for example, deliver aid and oversee the implementation of support. This attached the people to their elected officials even more than if there had been an independent bureaucracy. So here the bureaucracy was implementing policy of the Assembly, with the representatives often the face of the bureaucracy. Imagine that today, if your elected representatives were actually delivering the aid called for in the bills that they support and looking in on individual voters. That's what's happening here. To be denied the ability to vote for your representatives was in fact, from their viewpoint, to be denied the benefits of the very bureaucracy, personal and immediate, that had implemented governance. My hunch is that this sort of bureaucracy may well have had less corruption because there were fewer people involved and greater supervision, along with the ability of people, which there are some examples of, petitioning the legislature if the relief they've been granted isn't delivered properly. Next, the mutability of laws, and I deliberately use the word that Madison uses in 1787 in his Political Vices. So, scholars have looked with skepticism on the method of governing of early state governments for a number of reasons, and this has affected the view of the colonies. Madison described the, quote, mutability and, quote, multiplicity of laws, and as the concept of separation of powers has taken its place as a fundamental tenet of good governance, we tend to take a pejorative view of systems that don't have separated powers. I have news for you, though. Discretion is a facet of the rule of law if it is used to apply the principles of the law fairly in circumstances in which the law is unclear, vague, or silent. Laws apply uniform standards, but unfortunately they have irrational results on the margins of their application. But even knowing this, what might appear at signs of instability, think democracy run amok in a few years, was already going on in 1764, and it's simply the exercise of discretion to facilitate the fullest implementation of principles to best care for the vulnerable in society, or those with rights. Look at the resolve there in chapter 77. Keep in mind that there's always discretion in government. For example, the executive branch of state governments today has the pardon power, and they don't have to have a reason to do it. Judicial discretion abounds, including in a number of venues, when the black letter law is unclear, in trial procedure, including bail, continuances, other pretrial motions, in the application and review of appeals. And also there is discretion within the actions of a bureaucracy today. Who hasn't seen it? A smile, and in other places around the world, handing money. Graft is a kind of discretion at the behest of perverse incentives. What's happening in 1764-65 is laudable. The Assembly is applying a discretion that adhered to a regularized set of values and rules in order to achieve greater effectiveness of its governing principles in cases when those principles are at risk of not being implemented. Now, the use of discretion in colonial governments was a signal that they had departed from their English cousins' monarchical model. In a government where the source of power is through a monarch, discretion is more likely to be preserved by the monarch because they use that to curry favor and with it power. Now, there were tensions with Parliament, even in 1764-65, over a number of issues. But here's what I think came of those. These areas of tension, strangely enough, actually exacerbated tensions in a manner that made and reinforced colonial perceptions of their fully empowered government. Because their powers were so expansive, in the few areas in which they were not fully capable of governing because of parliamentary exercise of authority, and there are examples here of macroeconomic issues, including currency, for example, this actually exacerbated tension between the mother country and the colonies because they looked so anomalous from a colonial perspective and incongruent with the colonial notions of governance. So, some conclusions for you here. The manner in which the colonies governed contributed significantly to their perceived self-empowerment and provided a lived experience, a backdrop in operating governance for the arguments they formulated about their power and the nature of the governance that found expression in the Declaration of Independence. The nature of the governance was an expression of the people about the proper balance of liberty and stability, of freedom and order, expressed through the laws and procedures, the length of process, the timing of decisions, the nature of accountability, and the use of discretion. Colonial governance had come into its own prior to Parliament's first forays into taxing the colonies in the wake of the 7 Years' War. The standard story is that the colonists had to learn about governance quickly in the wake of Parliament's assertions of powers. No. The colonial governments were already acting as fully empowered governments by 1764. So, as the Sugar Act was being passed and the Stamp Act envisioned, the clash between Parliament and the assemblies was destined to be between institutions with two fully formed notions of governance, incompatible with each other. Colonial arguments about governance were certain, confident, not tentative and searching. They were grounded, as they were, in operating governments of inherent authority that demonstrated the validity of their arguments as the dispute with the mother country unfolded. The fact that the colonists in 64-65 immediately rejected the contention that Parliament had a right to tax them was a sure sign of mature notions of governance as part of the colonial rejection of a larger framework of English governance. It wasn't to be a disagreement from the colonial perspective about whether or not to tax tea, sugar, molasses. The dispute was over whether Parliament or the colonial assemblies had the power to levy the taxes, and more fundamentally, over what the breadth of power was of each, the assemblies and Parliament. If a colonial conceptualization of their power was vindicated, the only possible role for Parliament was to regulate relationships between states within the empire. Its power would only be regulatory and not fundamental. Already by 1764, what was lacking as to the colonial assemblies was not practice in the exercise of power, but rather only an articulated ideology of independence to explain to those in the mother country that the colonies were already self-governing. Parliament wanted to exercise imperial power and to govern in ways that brought the colonies and the mother country into greater unity under Parliament's control. The colonial assemblies responded with an assertion of their own mature conceptualizations of governance, a conceptualization in which power within the empire was decentralized and the assemblies continued as governments of inherent authority. In the clash between Parliament's assertions of power and mature notions of colonial governance, unity was the loser. The colonies' reaction to Parliament's assertions of power was not to govern differently, but rather to conceive of their governance in relation to Parliament in new ways. The struggle that had existed between colonial governments and governance and governors and the Board of Trade became struggles with Parliament. This raised the stakes in the dispute and led the colonies toward a clarifying in which they found only two possible outcomes from the colonial perspective, either a more federal system or independence. The tragedy from the British perspective is that a federal system of devolved power, a commonwealth, would eventually be the answer to a splintering empire. But at the time, in the wake of the 7 Years' War, the colonial proposal for how the empire ought to operate so that they can continue governing as they had was a non-starter from the British perspective, leaving the colonists only one option, a declaration of independence. Now, I'll just add, if you think about it from the British perspective, what the colonists were asking was for a re-empowerment of the monarchy, which is what they certainly weren't going to do, because that's what had been constrained in the wake of the Glorious Revolution. From the English perspective, rights were more secure, liberty greater in the wake of the Glorious Revolution because the king's powers were constrained. And what the colonists were doing is essentially asking, in a way, to undo that. It was a non-starter. Thank you very much. Any questions? I threw a lot at you, I know. Yeah, I would just draw, let you finish your question, but I would draw a distinction this way between governments of inherent authority and limited governments. And all government at that time were governments of inherent authority. They had unlimited power. The only powers, the only limitations, for example, on monarchical power in a general sense were the ludicrous. In other words, could the monarch order everyone in the realm to kill themselves? No, that's just ludicrous. Well, I think it's always good as Americans that we have debates about what the powers of our governments are, sure. And that's what's novel about the Constitution, is it creates, really for the first time, a big, powerful, but limited government. So what the Constitution has within it are, in fact, two different kinds of government. It has governments of inherent authority, state governments, and then a new government that was a government of limited and delegated powers. And British constitutionalists looked at it and said, that's a farce. Such a thing can't exist. It'll collapse. Well, look, the Constitution is fading into the mists of history the way Chaucer has, right? It's 250 years old. And we struggle with the history to know what they meant at the time, but then also more generally, whether we should even adhere to that, right? They're vocal advocates for a thing called a living constitution, that we shouldn't be hidebound by a document and the interpretations that are, 21 years old, and that it should do more to serve us today. I mean, that's a lively debate that goes along, that's among scholars today. And Dr. Friedman, thank you for being here today, my friend. Not that I've found. I think they're taken aback by it. There's been a long period in the colonial history that some scholars describe as benign neglect, in which the English and Parliament are simply dealing with other issues. And there are a series of developments between, say, 1700 and 1730 that turn the Atlantic from a barrier into a bridge. And these are commercial, economic, political, transportation that actually bring the colonies and the mother country closer to each other. And in the course of doing that, they don't always like what they find in the other, right? Englishmen travel to Virginia, and some of them are horrified because half the people are enslaved. And they go, this isn't the land of liberty. But then also there's a large contingent who appear to be outside of the bounds of hierarchical order, which is an important English concept to control people, to have a social order. And the colonists, on the other hand, travel to the mother country and say, wow, this is horrifying, the number of people that are completely impoverished, devoid of land and the ability to support themselves. Their rights that they claim are an illusion. They don't really have them. So the more that they knew each other, the less, and the 7 Years' War increases this sense, the less they feel that they're sharing as a common people a common set of notions about culture, society, governance, and those sorts of things. But no, I think they're equally taken aback as the colonists are that Parliament would do this. What both sides are doing is trying to settle into a new relationship in the wake of the 7 Years' War. The empire is dramatically altered, and they're trying to figure out essentially a new way that they can find agreement in the empire. By the way, this is one of the great successes of the British. They stay powerful far in excess of their military might long after they should have faded from power, and it's because of diplomacy. But in this case, events unfold very quickly, and there's no effective diplomacy. Well, there was the sense that that are expressed on both sides. Burke, for example, one that the colonists do have some valid points about what their rights are, and this sense that at some point an island wasn't going to govern a continent. Oh, I think you just partly answered it, and I think that's a brilliant answer, that it's a combination of factors, right? There was some component of it when the Atlantic was clearly a barrier that self-governance necessitated the arise of English principles in a new environment to govern themselves. There was certainly some notion of that, right? I mean, if you took groups of, let's say, 10 people from 10 very diverse places around the globe, and you just deposited each of them on Mars and said, okay, how will you govern yourselves? I mean, the 10 people from the US Army would choose a very different route than the 10 people from France, or 10 Americans, or 10 Chinese. So there is something of the old world in the way that the English adapt to the new world and create governance. They do create assemblies. They do expect that they have rights there. So, but it's a combination of things, some of which you touched on. I think that's smart. Yeah. I think in answer to the first part of your question, I think too much is made out of the diversity. And sometimes even Jefferson is seen as kind of this dreamy figure who speaks of one America. But the fact was that the colonies that had been participating in the Continental Congresses had been acting in consort with each other. Every time they sent delegates, every vote they had, they were acting as one people. So I think it was less a stretch than some scholars of the Declaration of Independence would contend. I also think we make too much of the differences between them, in the sense that what I find across the 4 colonies I've looked at is what appears to be in evidence from their conduct in the Second Continental Congress, broad general agreement on the nature of what their rights are, and a shared sense that their freedom is under assault. You know, the odd feature of this is the British create some of this dynamic themselves. You know, they do point out, it's Governor Pownall was a keen observer of the colonies, and he had been the governor of Massachusetts and South Carolina, and writes in 1773, he says, there's no way they'll join together in rebellion. They're too diverse. But the British create, in some sense, the thing they share, which is pressuring all of them to lose their freedoms, what they were. So, if that answers your question. Yeah. I want to thank all of you for being here today and taking part in this conversation, and thanks for your support to hear my talk. I really appreciate it. And for the students that are here too, that I have fond memories of, thank you very much for being here, and you know, friends and former colleagues, thank you very much.